received a note from the jury, which I've marked as Court Exhibit 3. It reads as follows. Juror number 3 would like to request that she be excused due to feeling unable to properly evaluate the case. Now says the state.
Your Honor, I think this is a big case, and if she's at a point where she can no longer keep her oath, then I guess after you evaluate that, then that's a determination for the court.
Can we just a second here?
Sure.
My understanding would be that that would cause a mistrial.
Exactly, it absolutely would.
I don't know what that means. If she can't evaluate the case, and that means if she withdraws from the deliberation, that means 11 jurors are deciding the case. I mean, it makes me uncomfortable both ways, I guess. I don't really know what to say right now.
Essentially, obstructing the dynamite. I mean, this is...
No, this is not an Allen charge. Request. No, absolutely not.
That's for sure. Really, I mean, I don't want 11 jurors making the decision, but at the same time, I also don't know the extent of her anxiety.
We have a fine balance of not interfering with their deliberations and discovering what we need to discover in order to be able to appropriately rule on this. It would be my intention to maybe invite all the jurors in, advise them that if 1, 2 jurors should not be able to continue, that would result in a mistrial, and that we don't want to force anybody to continue if they're unable to do so. That we would ask that they evaluate where their positions are, and if possible to continue to deliberate. How does something like that sound to the state?
That's exactly what they
The only question I have is it possible to give that same statement without the mistrial claim? And I mean, I don't know what, if they then start taking a position. I don't really know how it's gonna make the other jurors react, I guess. My one concern. Well, I guess my idea would be just to take out the part of the mistrial and simply say the rest of it. Not sure how that would read. I'm trying to rethink it.
Well, what I'll do is I'll give them a recess period. Everybody can visit with themselves about what you want to do here, and I'll hear you when we come back after you've had some thought. I've done a lot of these, and this is new. Is that acceptable to the state? Is that acceptable to the defendant?
Yes, sir.
Mr. Chair, if you can knock on the door and invite the jury in. Ladies and gentlemen, we're going to take our morning recess at this time. During our morning recess period, it is your duty not to talk among yourselves about this case. It's your duty not to talk to the parties, the witnesses, or the lawyers about anything at all. It's your further duty not to talk to anyone else, to allow anyone else to talk with you, to say anything in your presence about this case. If anyone communicates with you in any way, need to let the sheriff know about it when you come in. Don't do any individual research or investigation on your own about any issue touching on this trial during this time. So with that, ladies and gentlemen, while everyone else, anything further for the record for the state?
Nothing further.
Anything for the defendant?
No, sir.
Ladies and gentlemen, I will excuse the 12 of you and ask that you return and assemble in the jury room. Don't deliberate while you're in there. I have to bring all of you out and count noses beforehand. And we'll say 10 minutes to the hour of 12. This will be a little bit longer than usual. But we'll do that. With that, ladies and gentlemen, you are excused. Right, should flag yours absent quorum. Anything to the record for the state?
Nothing I say.
Anything to the record for the defendant?
Yes, sir.
Meeting recess to 10 minutes to 12. That's fine. They can come on out. Okay.
Court will be in recess to 10 minutes to 12.